Today we're going to witness what happens when two sovereign citizens in Kansas take their nonsense straight into the courtroom and meet two judges who aren't having any of it. We kick things off with John Hanna facing a serious charge, but instead of addressing it, he launches into full sovereign mode. He challenges the court's jurisdiction, mentions the straw man theory, and even name drops the Department of Justice. The judge listens calmly, but you can tell she's been here before. "I'm going to run this court, not you," she declares, absolutely shutting him down. This is courtroom control at its finest. The judge doesn't flinch, doesn't feed the antics. Just firm, focused authority. And this is only the beginning.
Are you Mr. Hanna?
Yeah.
All right. This is case number 2024 CR 420, State of Kansas versus John Hanna. Mr. Hanna, it looks like you've been charged with one count of sexual battery. That's a Class A misdemeanor. That can carry up to a year in the county jail and a fine of up to $2,500. So let's talk about how you might want to handle your case. This is just the time just to let you know what your charges are. Did you get a copy of the charges against you?
Of course not. I haven't even been found guilty on the sanction, the write-up while I'm in here.
Well, of course you're not going to be found guilty yet.
But I mean, I don't mean to interrupt you, but that's the procedure. And I mean, we could talk to the Department of Justice about the jurisdiction of the case as well. We can take it to that extent, but you can go ahead and continue. I would like to challenge the jurisdiction on the charge. I want to state that for the records as well. Will you continue? My apology.
All right, guys. Now it's time to see what happens when Hanna tries to outmaneuver the system. Spoiler, it backfires. After failing to shake the court's authority, he pivots and requests a public defender. But the judge sees right through it. "Taxpayers won't be funding your defense," she says, laying it out with brutal clarity. It's one of those moments where courtroom patience wears thin, and you can feel it. The judge raises his bond to $7,500 without hesitation. And even after all that, Hanna still attempts to debate jurisdiction. The judge's final response is surgical. "You're there. I'm here. That's jurisdiction." It's a moment that silences the room. Reality hits hard, and sovereign theatrics don't stand a chance.
Mr. Hanna, I'm going to run this court, not you. And you can start off with the sovereign citizen crap about jurisdiction and everything else if you want to.
I'm saying, I understand that. I'm just saying, but
it's not going
we
to
talk
get
to the Department of Justice as well, because you know who the director of the Department of Justice is, right?
That's just fine. You can do whatever you want.
We'll tell him now.
Anyway,
He'll be waiting on an indictment on you.
In any event, you're charged with one count of a sexual battery, Class A misdemeanor. Are you going to have an attorney to represent you, or do you want the court to appoint somebody to represent you?
You can appoint me one, and I'll have an attorney later on when I find one.
Things go from bizarre to alarming in this next part. Hanna, who made a mockery of the court, somehow gets released from jail. When his next court date arrives, his name is called, but the courtroom is met with silence. He's a no-show. The tension builds as the judge and prosecutor scramble to understand what happened. How does a man charged with serious offenses and who defied courtroom norms just vanish? The state brings up his background and erratic behavior, raising even more red flags. The courtroom buzzes with quiet confusion. This isn't just defiance. It's a full-on disappearance, and the judge is about to drop the hammer.
Okay, I'm going to go ahead and give you a hearing date on the misdemeanor control docket. Your next hearing is going to be November 18th at 9 o'clock with Judge Webster. That can be by Zoom. Mr. Canfield, what's the state's recommendation on bond here?
Your Honor, in addition to the sexual battery against a deputy, the defendant also has been convicted of aggravated domestic battery, and aggravated escape from custody. So at this time,
on those cases.
the state's recommendation will be a $7,500 cash or surety bond.
Those charges aren't even my record anymore. For legal detainment and
Very well, the court's going to go ahead and set your bond at $7,500 for security.
Maybe he's facing a grand jury.
If you can, sounds like you can afford your own counsel, so I'll let you go ahead and see about doing that. If you can't afford it, when you get around to your next hearing, you can ask the judge to appoint counsel for you. But I've given you your next hearing date. You know what your bond is. You'll need to stay with the sheriff until such time as you are able to execute your bond.
And so we didn't address the jurisdiction issue either, right?
The fact that you're where you are and I'm where I am means that I have jurisdiction.
This is where the courtroom gets serious. The judge wastes no time issuing a bench warrant for Hannah's arrest and doubles her bond to $15,000. But here's the jaw-dropping part. There's no record that the original $7,500 bond was ever paid. So the obvious question becomes, how did he get out? No one has an answer. The prosecutor admits the paperwork is missing, and even the court clerks seem confused. It's a breakdown in the system that let a sovereign citizen slip through the cracks. The judge tries to patch it by issuing clear orders, but the damage is done. This isn't just about law, it's about accountability. And right now, everyone's trying to figure out where the system failed.
Will now be on the record in Hannah 2024 CR 420, State of Kansas versus John Raymond Hannah. Jared Regier for the state, defendant pro se, but does John Hannah appear? Again, I called a while ago and no answer, so John Hannah fails to appear. Mr. Regier, recommendations on a sexual battery charge dating back to August 30th, 2024. The defendant was to make a $7,500 cash or surety bond, although he was very combative and challenging at the time.
Your Honor, I do have some notes from the initial hearing on September 6th before Judge Sanders that would appear to at least marginally refer to what the court is referring to insofar as the defendant's attitude at the first hearing was concerned, or perhaps demeanor is a more appropriate term for it. I do not have anything in my file insofar as an appearance bond is concerned. Perhaps the court knows something that I do not know, but I am not showing any affidavit from the jail either.
I am not showing anything in the file concerning the bond, although I'll check my queue real quickly and see if it's something that might be in there. Well, I'm not seeing it, but yet I don't know how I could have gotten out of jail without making a bond.
And my notes do appear to suggest that that the defendant did appear in custody. To cut it to the quick, Your Honor, the state will be recommending, based off of the amount of the bond and the charges before the court, at the very least $15,000 cash or surety, or no bond hold, depending on which way the court determines is appropriate. The state would also defer to the court as to whether a bench warrant or a bench bond forfeiture should be the court's order at this time.
Well, I'm going to issue a bond forfeiture, but if he didn't post the bond, then of course we can't enforce it. But I'm ordering a bond forfeiture. I'm ordering a bench warrant for the failure to appear, and the new bond will be set at $15,000 cash or surety.
Thank you, Your Honor.
You're welcome.
Now, it's time to meet Sovereign Citizen number 2, Estrada Jr., and he enters the courtroom with all the same energy. Pulled over for fake plates and no insurance, he immediately tries to speak over the judge. But this isn't a statement. It's a sovereign citizen declaration. He claims to be the living man, separate from the legal name on the citation. The straw man theory returns in full force. The judge tries to cut through the nonsense, asking if he wants a lawyer, but Estrada dances around the question. He's convinced he's not subject to the law because he's traveling, not driving. It's absurd, but strangely captivating to watch.
We are on the record in 2024 TR 617. Sir, you may need to scoot over a little bit to be picked up by that microphone. I'm not sure, but sometimes you have to be in the middle with it. Mary Ann Shirley appears for the state. Are you Abel Estrada Jr., sir?
Yes, if I may, can I make a statement?
No, not yet. Okay, sir, you are charged in count 1 with on or about the 21st day of August, 2024 in Greenwood County, state of Kansas. Then and there, contrary to the statutes of the state of Kansas, unlawfully operating a vehicle, to wit, a 2011 GMC Acadia, upon a highway which does not have the signed license plate. I think they mean that the vehicle didn't, not the highway, but your vehicle did not have the assigned license plate properly affixed to the rear of the vehicle, showing the current registered year. And this is an unclassified misdemeanor. It is punishable by up to $2,500 in fines and a possible sentence of up to 6 months, 30 days minimum, up to 6 months, although probation is usually granted. Now, sir, did I not just have you in municipal court recently on the same charge?
Yes, and I don't understand why am I seen again, because that would be double jeopardy. I'm saying for the same,
Sir, you haven't been tried on it. You
I
just
have,
had a first appearance on it. And
I have-
apparently the city prosecutor must have dismissed it and refiled it over here for whatever reason I know not.
He repeats his belief that the charges apply to his legal fiction, not him. The judge, clearly experienced with this rhetoric, doesn't bite. She lays out the procedure calmly, public defender options, next court date, and what comes next. But Estrada keeps interrupting, thinking he's exposing some hidden legal truth. The court, unfazed, continues without reacting to the theatrics. The contrast is striking. Logic versus delusion, law versus fantasy. Despite the madness, the court moves forward. And you just know, if Estrada pulls a Hannah and skips his next appearance, the consequences will be swift and severe.
But as I recall, your plea was not guilty. Is that still your plea?
yes, but I'm here to make a separation between my name. My name is Abel Estrada with low caps. This name on the top, I don't know if you can see it. This name on the top is my straw man. I am the man, and this is the straw man. So if you're calling the straw man, I'm here to represent the straw man, but I'm Abel Estrada Jr., the man, the living man.
I'm calling the living man.
So I
So are you going to have an attorney? Are you going to need to apply for court-appointed attorney, or will you be waiving your right and representing yourself?
no, of course, I wanted to have an attorney, but I still haven't not made my statement, which is,
Are you going to hire an attorney or apply for court-appointed?
I cannot afford an attorney, but I need to make my statement that
Let me get a few things worked out, sir. You're going to apply for an attorney, so you'll need to fill out an application for court-appointed attorney, and the deputy down there can give that to you. Make sure you fill that out and get that back to me before this hearing is over. Make sure you fill in all the blanks and you sign it and you date it where it says to, because I generally don't consider those if they're not thoroughly completed. And then you call back to my assistant, Missy, later in the week to see if one is appointed. and who that will be. Do you need Missy's number, or did you take it down earlier from the other hearings?
No, I don't have.
All right. Missy, do you want to give him your number?
620-583-8155.
And then Missy, when is his next court date?
Well, I haven't explained my position.
Sir, we're not going to have a trial today. You're going to need to talk to your attorney before you have a trial. So Missy, when is his trial date?
I wanted to move,
Sir, please do not interrupt. Missy, when is his, and we won't set it directly for, do you want to set it directly for trial, or do you want to set it for a status so I can
I
check
don't
in with you after you talk to your attorney?
I don't know what the status means.
Well, let's set it for a status, Missy, or control.
November 22nd at 10.
You, sir, will need to be back here by Zoom November 22nd at 10 a.m. Are you on bond? Let me check.
Why would I need a bond?
Complaint from the cause. There is no bond on the file, and it is an unclassified misdemeanor. So I'm not going to make you file a bond since it's an unclassified misdemeanor. If you fail to come to court, though, most likely a warrant would be issued anyway, and you'd be taken into custody. But as long as you come to court when you're told to, that's not going to be a problem. So you're going to call and get your attorney, or find out if you have an attorney.
I haven't given a chance to
You do not need a bond, and you have your court date.
7. All right, guys. Here's where it all comes to a head. Estrada makes one final push to get his sovereign theories into the record. He talks about driving in the private, insists nothing illegal happened, and demands dismissal with extreme prejudice. But the judge? Not even fazed. She simply ends the hearing, letting the absurdity hang in the air. It's a perfect snapshot of delusion crashing into reality and losing. These two men walked into court thinking they'd rewrite the rules. Instead, they got a crash course in how law actually works.
Number one, I want to move to a motion to dismiss this case because I didn't try for this, and I have the license plates, both license plates. I was not driving anything unlawful or illegal. I'm living in the private. I'm driving in the private, and so I want to move for dismissal with extreme prejudice. And also, I want to make sure that you understand that I want to keep all my constitutional rights. So far, my constitutional rights are being trampled over right now by yourself because you're not giving the chance to speak. I have not given the chance to speak. You're just going over and over. And I'm requesting that you remove this case because this is double jeopardy. I already appeared in court for this thing.